and welcome back to another episode of Courts This Week presented by Livelaw. I'm your host Ostika Das and I'll take you through the most significant courtroom developments from this week. From the Supreme Court to local courts, I've got you covered with crisp and clear summaries. But for a deeper understanding, I will always encourage you to check out the news articles available on our website www.livelaw.in. In today's episode, we are going to talk about the latest developments relating to the Manipur ethnic clashes, Supreme Court's response to the suspension of a Kashmiri lecturer who argued before the Constitution Bench hearing the Article 370 pleas, RJD leader Prabhunath Singh's conviction in a 1995 double murder case, and much more. So let's dive into the headlines. Let's begin with two important developments about Manipur, which has been witnessing ethnic clashes since May. As you know, after expressing concerns over the pace of investigation, the Supreme Court has started proactively monitoring the situation on ground. Earlier this month, it directed the Central Bureau of Investigation to handle 11 FIRs relating to cases of sexual violence with the assistance of 5 senior officers from other states. Last week, it accepted the suggestion of the central government to transfer the sexual violence cases being investigated by the CBI, now 27 in number, outside the state of Manipur to Assam, and passed a slew of directions. The court's directives sought to streamline legal proceedings, provide access to justice, and facilitate the probe being conducted by an all-women committee comprising retired High Court judges that was created to look into the humanitarian aspects of relief, remedial and rehabilitation measures, and restoration of homes and places of worship in the violence-hit northeastern state. In its order, which has been uploaded this week, apart from directing the union government to bear the expenses associated with the committee's work, including administrative costs and accommodations, the Supreme Court has also asked the Ministry of Electronics and Information Technology to ensure the expeditious creation of an online platform where people can submit relevant material and information for the committee's consideration. During this week's hearing, the Supreme Court bench headed by Chief Justice D.Y. Chandrachud also directed the union government and the Manipur government to ensure the distribution of essential supplies including food and medicines to those affected by the recent violence in Manipur. This directive comes in response to concerns raised by the Judges Committee about blockades preventing rations from reaching people in the More region of Manipur. The court has urged the government to explore all options, including airdropping rations, to address this issue. Additionally, the court was informed about an outbreak of measles and chickenpox in some relief camps, highlighting the need for immediate humanitarian assistance in the region. The court was also informed about other issues arising out of the region during the course of the hearing, such as demolitions in the state or the destruction of over 200 churches during the ethnic clashes. This matter will be taken up again next week on 6 September, when the court is expected to consider the findings of the Justice Geeta Mittal-led Judges Committee. The Supreme Court sentenced former MP and Bihar's Rashtriya Janata Dal leader Prabhunath Singh to life imprisonment in a 1995 double murder case. Singh was also directed to pay compensation to the victims' families and received a 7-year sentence for an attempt to murder charge. 2 weeks ago, the court had reversed Singh's acquittal in the case in which he was accused of murdering 2 people near a polling booth for not voting as per his suggestion during the 1995 elections. In a strongly worded judgment, the Supreme Court called the trial shabby and the investigation tainted, which showed the high-handedness of the accused, who was at the time of the incident a sitting MP of the ruling party. In 2008, a Patna court had acquitted Singh citing lack of evidence. This acquittal was later upheld by the Patna High Court in 2012. Consequently, the brother of one of the victims challenged the acquittal in the Supreme Court. Pointing out several lapses in the trial, the Supreme Court called the case an exceptionally painful episode of our criminal justice system. Let's now turn our attention to the caste survey conducted by the Bihar government, which received the green light from the Patna High Court last month. Last week, the central government sought and was granted permission to submit its view on the survey. Solicitor General Tushar Mehta told the bench headed by Justice Sanjeev Khanna that this exercise may have some ramifications, but quickly clarified that the centre was not for one side or the other. This week, this centre submitted 2 affidavits in quick succession. The latest affidavit was submitted retracting the earlier one, which stated that no entity other than the central government had the right to conduct a census or any action akin to a census. The second affidavit clarified that this statement had been included inadvertently. The latest affidavit has, however, retained the submission that a census is a statutory process governed by the Census Act of 1948, which was enacted in the exercise of the powers under entry 69 of List 1 of the Constitution's 7th schedule, and that the said act empowers only the central government to conduct a census, besides underscoring the government's commitment to uplifting scheduled castes, scheduled tribes, socially and educationally backward classes and other backward classes in accordance with the Constitution and the applicable laws. During this week's hearing on the remission granted to Bilkis Bano's rapists, the Supreme Court questioned whether the non-payment of fines imposed on the convicts would affect their remission after senior advocate Siddharth Luthra informed the court that his client has recently paid the amount imposed on him as a part of his sentence. One of the grounds on which the petitioners had sought the convicts' remission to be set aside was that they had not paid fines and would consequently be required to serve a default sentence. Advocate Vrinda Grover had also argued that the willful non-payment of fines, especially when the Bombay High Court had directed the amount so collected to be given to Bilkis Bano as compensation, clearly suggested a lack of remorse. Luthra, however, strongly resisted this contention, arguing that non-payment of fines wouldn't have any legal consequence on the remission, as default sentences, if any, would be subsumed within the life sentence imposed by the sentencing court. Besides this, the senior counsel pointed to the convicts not being sentenced to die or handed fixed-term sentences by the trial court or the Bombay High Court to argue that the possibility of reformation could not be precluded. He stressed that the sentencing aim of reformation could not be said to be unachievable in the current case. After hearing his submissions, the court adjourned the hearing until September 14th. And don't forget to visit our website www.livelaw.in to read our detailed reports on this week's hearing. Next, let's talk about the Article 370 hearing. Right at the beginning of this week, the Supreme Court Constitution Bench headed by Chief Justice D.Y. Chandrachud requested the Attorney General to investigate the suspension of a Kashmiri lecturer by the Jammu and Kashmir Education Department. The lecturer, Zahur Ahmad Bhatt, had recently appeared in person and argued before the bench against the abrogation of Article 370. Senior advocate Kapil Sibal raised the issue, stating that Bhatt was suspended shortly after taking leave to appear in the case. The Solicitor General, however, noted that there might be other issues, but Sibal pointed out that the suspension order referenced his court appearance. The judges expressed concerns about the timing of his suspension and urged Attorney General R. Venkataramani to investigate. Another key development from this week's hearing is that the Supreme Court asked the centre for a timeline to restore statehood to Jammu and Kashmir, which was downgraded to a union territory in 2019. The government couldn't provide a specific timeline but confirmed that union territory status for Jammu and Kashmir was temporary. This week, the Attorney General continued his submissions and was joined by senior advocates Harish Salve, Rakesh Dwivedi and V. Giri. Visit our website www.livelaw.in to read our detailed reports on the Constitution Bench hearing, and stay tuned because the debate will continue on Monday. Upholding an individual's fundamental right to choose a life partner, the Supreme Court, in a significant development, set aside a Madras High Court ruling that marriages performed in advocate's office were not valid under the Hindu Marriage Act 1955 and held that self-respect or Suya Mariathai marriages did not require public solemnization or declaration. For context, the issue was centered on Tamil Nadu's self-marriage system, which was statutorily incorporated into the Hindu Marriage Act by the insertion of Section 7A through a state amendment. This provision dispenses with rituals and the involvement of priests and recognizes marriages that are just declared in the presence of friends or relatives. The controversy was over a 2014 Madras High Court ruling in S. Balakrishnan Pandyan, in which the court held that marriages performed by advocates were not valid and that Suya Mariathai marriages could not be solemnized in secrecy. This precedent was followed by the High Court in a recent decision while refusing to rely upon a self-respect marriage certificate issued by an advocate and dismissing a habeas corpus petition filed by a man who alleged that his partner had been illegally detained by her parents. This matter went up in appeal to the Supreme Court, which has now disagreed with the Madras High Court's judgment in Balakrishnan Pandyan and categorically stated that not all marriages require public solemnization or declaration, noting that couples often refrain from public declarations due to familial opposition or safety concerns. Having said this, the court also cautioned that advocates should not solemnize marriages in their professional capacity but may do so in private roles as friends or relatives. In another significant development in Hindu law, the Supreme Court has ruled that children born from void or voidable marriages are entitled to inherit their parents' share in Hindu joint family property under Hindu Mitakshara law. The court has, however, clarified that such children born out of invalid marriages cannot claim properties of co-partners other than their parents. The central issue was whether children born from void or voidable marriages have a right to ancestral property under Hindu law. While Section 16 Clause 1 and Section 16 Clause 2 of the Hindu Marriage Act grant legitimacy to children from such invalid marriages, Section 16 Clause 3 restricts their property rights to their parents' self-acquired property. A bench headed by Chief Justice D.Y. Chandrachud has now delivered its verdict in a reference against a 2011 judgment on the scope of Section 16 Clause 3 of the Hindu Marriage Act. Answering the reference, the court has held that children born out of invalid marriages are entitled to such property which would devolve upon their parents on a notional partition on their death in an effort to harmonize the Hindu Succession Act with the mandate of Section 16 Clause 3 of the Hindu Marriage Act. At the same time, the court has also explained that such children are not considered co-partners by birth in the family. It is important to note that this ruling would apply solely to Hindu joint family properties governed by Hindu Mitakshara law. This week, the Supreme Court deferred the consideration of an application filed by the central government seeking to withdraw its oral undertaking given in November 2022, pledging to maintain status quo with respect to the release of genetically modified or GM mustard. This is the first time a transgenic food crop is proposed to be commercially cultivated in India, leading to environmentalists and research organizations raising apprehensions relating to biosafety and ecological protection. The centre has sought to be discharged from its earlier commitment and proceed with the environmental release of GM mustard, especially considering the upcoming September and October sowing season. During this week's hearing, ASG Bharti urged the court to allow the government to either proceed with its full plan of environmental release in the upcoming season or to sow GM mustard at 8 out of the 10 sites where they were sown last year. The petitioners, on the other hand, argued against any open field trial, expressing concerns about biosafety and the potential contamination of non-GM crops. To this, the law officer said that field trials have been going on for a long time, assuring that the current stage of environmental release was a culmination of over a decade's research. Despite the government's appeals and assurances, the bench headed by Justice B.V. Nagaratna refused to allow any precipitative action before a hearing, emphasizing the importance of environmental preservation and observing that there would be more sowing seasons in the years to come, but environmental harm cannot be reversed. After making these observations, the bench directed the hearing to be adjourned until 26th September. The Supreme Court had earlier directed a 10-day status quo to be maintained with respect to the demolition drive conducted by railway authorities in a settlement near railway tracks in the backyard of the Krishna Janmabhoomi in Mathura. Railway authorities have defended the demolition, citing plans to convert a rail stretch from narrow to broad gauge to facilitate the operation of trains like Vande Bharat. Residents, however, have cried foul and alleged unfair eviction from the predominantly Muslim settlement. This week, however, a bench headed by Justice Aniruddha Bose disposed of the plea, declining to extend the status quo order. The court permitted the affected residents to approach the local court hearing the land ownership suit, while questioning the need for further intervention by the Supreme Court when remedies could be pursued in the lower court. The bench emphasized that a writ court was not the proper forum to decide property rights, nor could it run parallel proceedings alongside the suit court. In an interesting development, a Supreme Court bench of Justices M.M. Sundaresh and J.B. Pardiwala expressed doubts about the court's earlier order passed by another bench headed by Justice K.M. Joseph, who has since retired, allowing activist and Bhima Koregaon accused Gautam Navlakha to be released from detention and placed under house arrest due to health concerns. Navlakha has been in custody since August 2018 in connection with the 2018 caste-based violence at Bhima Koregaon and for allegedly having ties with the proscribed Communist Party of India Maoist. Before adjourning the hearing of a plea filed by Navlakha to shift his house arrest location, the court raised concerns about the house arrest order setting a wrong precedent. It directed the National Investigation Agency to file its counter affidavit within 4 weeks and directed the matter to be relisted at the end of October after 8 weeks. Notably, the central agency contested the house arrest order in court during the hearing and claimed that Navlakha had to pay 1 crore for surveillance expenses, a figure that was disputed by his lawyer. Navlakha's bail plea is also currently pending before the Bombay High Court. The Supreme Court refused to entertain a petition challenging Telangana government's newly introduced policy of 100% reservation for local candidates in competent authority quota in medical colleges established in the state after June 2014, which is when Telangana gained statehood. The state government's policy, introduced on July 3rd, reserved all competent authority quota seats for local MBBS aspirants, arguing it was aimed at bolstering local healthcare and access to medical education. A group of MBBS aspirants from Andhra Pradesh, however, challenged this policy as illegal, arbitrary and violative of fundamental rights, including the right to equality. A bench headed by Justice P.S. Narasimha rejected this plea, citing a similar petition being heard by the Telangana High Court and expressing disapproval of the petitioner's attempt to institute parallel proceedings in the Supreme Court. The Cauvery Water Management Authority has informed the Supreme Court that the state of Karnataka discharged 1,49,898 cusecs of water at Biligundulu on the interstate border between 12th and 26th of August this year. This update comes after Tamil Nadu requested the court's intervention last month in compelling Karnataka to release 24,000 cusecs of water for the remainder of August. Last week, after acknowledging its lack of expertise on the issue, a bench led by Justice B.R. Gavai had sought a report from the CWMA. The authority has informed the bench that Karnataka has complied with its directions to release 10,000 cusecs of water from the Krishna Rajasagar and Kabini reservoirs over the last 2 weeks of August. The cumulative flow realized during the 15-day period was found to be 1,49,898 cusec. The court was also told that Karnataka has been asked to ensure 5,000 cusecs of water flow at Biligundulu for the next 15 days in the latest meeting. This development is part of the ongoing Cauvery water dispute between Karnataka and Tamil Nadu dating back to 1974, which reached the Supreme Court after the tribunal in 2007 finalized the water sharing formula. The Madras High Court has initiated suo motu revision against a decade-old order that discharged former Tamil Nadu Chief Minister O. Paneerselvam and his family in a disproportionate assets case. Justice Anand Venkatesh expressed reservations about the trial court's order and criticized the Directorate of Vigilance and Anti-Corruption for its well-orchestrated modus operandi in the case. The court noted that the DVAC filed a supplementary charge sheet after a change of government, effectively wiping out the initial charge sheet. The prosecution then withdrew the case, citing the second charge sheet, which exonerated the accused. In this way, the accused is discharged and the solemnity of a judicial proceeding before the court is reduced to a cruel joke, the judge observed in his order. It may also be noted that Justice Venkatesh had earlier exercised suo motu revision powers against orders discharging other Tamil Nadu ministers accused in corruption cases. The Kerala High Court has ruled that the absence of specific statutory provisions should not restrict courts from allowing past maintenance claims for senior citizens. A division bench of the court held that a senior citizen's patience and respect for their children, manifesting in the form of their initial reluctance to approach the court, should not be used as a reason to deny their past maintenance claims from their children. This ruling came in response to an appeal by a Christian senior citizen seeking arrears of maintenance from his children, which had been rejected by the family court on the grounds that Christian law did not allow for such past maintenance claims. That wraps up this week's Legal News Roundup. But before I go, I have a little request from the entire livelaw team. We are an independent, fact-driven media organization that is committed to fearless and ethical journalism. To keep delivering your daily and weekly legal updates, especially in this dynamic audio-visual format, we need your support. So don't forget to do the Fantastic 6. Give our video a thumbs up, share it with your family, friends, classmates and colleagues. Make sure you subscribe to our YouTube channel. Drop your thoughts and feedback in the comments below. Tap that bell icon to get your notifications, and lastly, swing by our website at www.livelaw.in for our in-depth reports. I'm your host Ostika Das, and I will see you again next time.